Today we will present the case Powell and McFarland 1977. We will start with some facts regarding Powell. Knowing Powell's background is relevant as it sheds some light on his circumstance and may lead to a better understanding of his character. Briefly, Powell was born on April 12, 1942, and his mother died when he was just 4 months old. His father played no part in his life, so he was brought up by his grandparents, Mr. and Mrs. Bishop. In 1956, they purchased Nutwood Farm and outbuildings, and this is where Powell resided. In 1951, McFarland acquired the disputed land for £470. On March 11, 1952, McFarland became the registered proprietor of the land with the land registry. However, in 1955, McFarland went to Bonn, Germany, where he stayed for 11 years and did not return during those 11 years. By 1956, the disputed land was vacant, and at the same time, Powell, who lived next door and was 14 years old at the time, decided to care for the land, and he did so for the next several years. For instance, at age 14, Powell decided to use the disputed land for grazing his beloved cow, Cashla. He later asked his grandmother, Mrs. Bishop, to write a letter to McFarland to see whether he would agree to such use. There is no evidence that McFarland ever received this letter, and because he received no response, Powell decided to continue with letting his cow Cashla graze the land and did significant amount of work relating to maintaining it, clearing it, adding fixtures to it, and setting up his business sign on the land. In the summer of 1956, he cut the hay on the land. In the same year, Powell, with the assistance of friends such as Mr. Jeffries and Mr. Skinner, made the land stock-proof, preventing livestock from escaping, by reinforcing the original fence and even by building new ones where needed. Further, to increase the mowing area, he did clearance work and got rid of tangled shrub and growth and cut a number of trees down. He later moved his beloved Cashla on the land and gave Mr. Jeffries permission to raise a goat there. Also in that same year, Powell created a water supply for the land by connecting water pipes. In 1962, he set up his own business and became a tree surgeon and planted his business sign, E. Powell & Co. Tree Surgeons, in the southeast corner of the land where it remained until December 1972. From time to time, because of his tree surgeon business, he used the land and parked lorries or trucks and other vehicles onto it. Over the years from 1958 to 1973, Powell continued to clear the land and repair the fences, but was doing far less compared to what he used to do. With this in mind, it is without a doubt that Powell had tended greatly to this disputed land and devoted several years to maintaining it. These facts were taken into consideration by the Lords when deliberating whether Powell had intended possession of this disputed land.
McFarland was gone from 1955 to 1967. He claimed that he and his wife started visiting the disputed land 3 to 4 times a year from 1967 to 1972, although they never saw any activities on the land of the nature relied on by Powell. Powell received a letter dated August 1972 from McFarland's solicitors, asserting McFarland's title to the land, but offering Powell a grazing agreement. Powell never accepted the offer. In May 1973, McFarland entered into a grazing agreement with the second defendant, Mr. Ransom, under which Ransom was entitled to the possession of the land and graze livestock for a period of 3 years. Powell's evidence that he carried out activities on the disputed land between 1956 and 1973 was to a considerable extent corroborated by witnesses who had themselves actually worked on the disputed land. McFarland counterclaimed that Powell trespassed upon the land by erecting an advertisement hoarding during the period of the 6 years before the commencement of the proceeding. To summarize the dispute, Powell was seeking to establish a possessory title to the land. He claimed that he had been in adverse possession of the disputed land since 1956 or 1957, and McFarland's right of action accrued to him at least 12 years before the issuance of the writ of action. McFarland pleaded that he had since 1952 been registered at the Land Registry as proprietor with the title absolute. Ransom, as the second defendant, disputed Powell's claim to adverse possession, and he claimed to be in possession of the disputed land by virtue of the grazing agreement between him and McFarland.
With reference to the main issue, Judge Slade gave the majority's decision. As the plaintiff brought his claim on the basis of Section 4.3 of the Act, the starting point of Judge Slade's judgment began with an interpretation of Section 10 of the 1939 Limitation Act. Section 10.1 of the Act reads, "No right of action to recover land shall be deemed to accrue unless the land is in the possession of some person in whose favor the period of limitation can run. The right of action shall not be deemed to accrue unless and until adverse possession is taken of the land." In short, the right accrues when the land is adversely possessed, which means possession not by owner's consent, and this right is barred 12 years after the date of accrual. However, Judge Slade noted that the Act does not define what possession entails. He therefore interpreted the word possession to bear its traditional English law meaning. He turned to case precedents in order to elaborate on the rule of adverse possession. The starting point is the presumption that the owner of paper title of the land has the possession thereof. In order to rebut this presumption and establish adverse possession, the possessor has to overcome two hurdles. First, one has to prove factual possession. Second, there must be animus possidendi, which is Latin for intention to possess.
The first hurdle of factual possession requires proof of exclusive physical control that is adverse by nature. This means the factual possession must first be exclusive. There cannot be another concurrent act of possession being carried out on the same piece of land. Secondly, adverse means the act cannot be sanctioned by the owner's consent. More specifically, the occupation must interfere with the landowner's intent for which the land should be used for. Judge Slade also noted that the threshold of the degree of factual possession varies from case to case and depends heavily on the circumstances of the case. He gave some examples of factors to be taken into account when assessing the degree of exclusive physical control required in each case. One of the examples was the nature of the land. He stated that an open land would require a lower threshold to prove sufficient factual possession because it is impractical to require absolute control over the open area. Another example was the manner in which land of a particular nature is commonly used or enjoyed. So to shortly summarize, the question to ask in the first hurdle would be whether the alleged possessor has been dealing with the land in question as an occupying owner might have been expected to deal with it, and that no one else had done so.
The second hurdle requires firstly proof of intention to possess, and this is to be inferred from the plaintiff's acts. To break this down, the squatter has to first show a clear intention of excluding the owner as well as other people from the land. Examples of doing so may include the case of Lay and Jack, where the court held that the defendant failed to claim adverse possession as he simply used the land until the time should come for carrying out the object originally contemplated. Secondly, this intention to possess must also be manifested to the world. In order to do so, the possessor's intent cannot merely be derived from an enjoyment of the use of land. It has to be inconsistent with the use as the true owner might wish to make of it. On this point, Judge Slade referred to the case Wallace. In other words, the possessor has to claim unequivocal intention of asserting his right to the possession of the piece of ground. To summarize the second hurdle, one has to prove the intention in one's own name and on one's own behalf to exclude the world at large, including the paper title if he be not himself in possession, so far as is reasonably practicable and so far as the processes of the law will allow.
Powell did not place a notice keeping intruders out or lock nor block the access to the disputed land in 1956 or 1957, which was the period during which Powell claimed adverse possession to have begun. He only used the land to the extent necessary to take various.
As a result of the test of adverse possession and the facts of the case, the court dismissed Powell's claim against both defendants with costs and McFarland being awarded £2 in nominal damages and Ransom being given a court order for possession of the disputed land.
The court also gave an opinion on the doctrine of imputed license. which was rejected in the Limitation Act 1980, while preserving the possibility of a license being imputed where the actual facts of the case warrant it. Judge Slade explained this doctrine in this case. Should the acts of intruder not substantially interfere with the present or future plans which the owners may have for the use of unbuilt land, the court will not treat the intruder as having dispossessed the owner for the purpose of Limitation Act 1939, because it will treat him as having been there under some imputed or hypothetical license or consent. If the court found imputed or hypothetical license, even if Powell had possession of the land, the court would be constrained to hold that his possession was adverse because the court would be obliged to hold that it was enjoyed under a license by law. In his own words, Judge Slade disapproved of the doctrine for the case at hand by saying that he finds it difficult to justify the imputation of an implied license in circumstances where the facts would not admit to the imputation of a license for any other purpose. If applied here, Powell's activities were not substantially inconsistent with any use to which the owner might have wished to put into it in the future. If Powell had succeeded in obtaining possession of the land in 1956 or 1957, Judge Slade will be constrained to hold that his possession was not adverse because it was enjoyed under a license imputed by law.